Hey there. Venue. Let's talk about it some. All right. We have limited time here, so again, doing selected topics. I have a gazillion videos, that's an actual mathematical number, on my website on a variety of topics. Just go to the YouTube site. And with this venue, I have videos that talk about venue in much greater detail. So what I'm going to do with you here today is go through 1391 and hit up some of the major points so we can go to other topics. All right. 1391 is the general venue statute. Remember that it does not apply to removed cases. Venue in a removed case is measured by looking at the district that corresponds to the state court. If the case is originally filed in federal court, then in most cases we're going to use 1391. There are three ways of measuring venue under 1391B. First one looks to place of residence. Second, it looks to where stuff happened, events, omissions, or property. And then this third one is a fallback. All right? Let's start with number one. Venue is proper in a judicial district in which any defendant resides, so long as they all reside in the same state. All right? So first, we're looking to where people reside. And second, Section B1 only applies if all of the relevant defendants reside in the same state. So we have to ask, where do the defendants reside? Well, this word resides requires us now to go down here to C, which tells us how to determine residency. All right? A natural person, and we can almost strike all of this out in the middle, natural person resides in the judicial district where they're domiciled. Remember at the beginning when I said domicile was super important? This is yet another example of where domicile rears its head. So if I'm a natural person, I'm domiciled in Florida, then for venue purposes, I reside in Florida. Residence means domicile. It's kind of weird when you think the definition of domicile is residence plus intent to stay indefinitely, right? So that what the statute tells you is residence means domicile, which means residence plus intent. That's kind of weird, dumb when you think about it, but whatever, it works. So ask where the defendants reside. So say, for example, you have somebody who's a citizen of Florida versus somebody who is a citizen of Florida who resides in Miami, and somebody who's a citizen of Florida who resides in Tallahassee. All right? Are all the defendants domiciled in the same state? Yeah. Therefore, they all reside in the same state, right? And therefore, venue is proper in a judicial district where any of them reside. Now, Miami is in the Southern District of Florida, and Tallahassee is in the Northern District of Florida. So venue would be proper in either of these districts. Let's add a third defendant. Pennsylvania lives in Pittsburgh, which is in the Western District of PA. Can we use 1391B1? No, we can't, because now they don't all reside in the same state. What if this person is not a citizen of the state of Pennsylvania? Instead, they are a German citizen who is domiciled in Pittsburgh, in Pennsylvania, but specifically within the Western District of Pennsylvania. All right? Well, you think that they're domiciled in the Western District of Pennsylvania, but now we go down to 1391C3. Where was it? Where'd it go? Oh, my bad. No, it's still the same result. Okay. I was thinking of different hypos, so let me erase this and give you the needed facts. Okay, so we were good, and when we had Pennsylvania, there we go, Pennsylvania, Pittsburgh, Western District of PA, that was fine. Now let's get rid of this person, And then let's add somebody who is, say, a citizen of Germany, lives in Berlin, so they're domiciled in Berlin, all right? How do you analyze venue here? And you would look at this initially and say, well, they don't all reside in the same state, right? So you can't use 1391b1. But actually, you can use 1391b1 because of section C3, which says a defendant not resident in the United States can be sued in any judicial district, and that the joinder of such a person shall be disregarded regarding venue over other defendants. So what that means is, suppose Florida sues Germany, all right? Well, venue will be proper over Germany in any judicial district if the German defendant were the only defendant. But here we have, and I don't know why I made this Florida versus Florida. We wouldn't have diversity. Well, we could have a diversity jurisdiction if it's a federal question. Okay. You can see I'm starting to get tired and second guess myself. I apologize for that. I have been teaching all day. And I've only said that about 10 times today, haven't I? All right, federal question. There's subject matter jurisdiction. So you have Florida versus Florida Miami, Florida Tallahassee, and Germany Berlin. Well, if Germany Berlin were the only defendant, then venue would be proper in any of the 84 districts. But what about this? It tells us that we disregard this person for purposes of venue, right? Go back to the statute. Disregarding and determining whether the action may be brought with other defendants, which means now when we're measuring residence for purposes of venue, that means all of the relevant defendants reside in the same state. And therefore, we can use 1391. They all reside in the same state. Therefore, venue is proper against both of them in either of the districts in which they reside, the Northern District and the Southern District of Florida. All right. Corporations. The language there is pretty complex, but I'm going to kind of distill it down to the basics that I think you need for the bar exam is, for a corporation to measure their residency, you have to ask whether or not they be subject to personal jurisdiction in the district, in a particular district. All right? So to measure the residency of a corporation, you ask what district or districts in which they're subject to personal jurisdiction. Suppose you have a corporation that's got its principal place of business in Florida, but the actual headquarters is in Miami. Okay? Well, for venue purposes, we're going to treat each and every district as if it was a separate state. We're going to be asking about the minimum contacts or other basis for PJ this corporation has with each of the districts in Florida. Now, I told you that this corporation has its headquarters, its principal place of business in Miami, right? So even though for purposes of personal jurisdiction, it had PJ with the whole state, for purposes of venue, we're going district by district by district. And treating the Southern District of Florida as a separate state, the corporation would have PJ with the Southern District of Florida. And therefore, under the statute, in any judicial district in which the defendant corporation is subject to the court's personal jurisdiction as if it was a separate state. And it's underscored down here. In a state which has more than one judicial district, and it's a corporation, the corporation is deemed to reside in any, not state, but any district within the state, which is contacts are sufficient to give it PJ as if this district were a separate state. Okay? So again, we're not talking about states here, we're talking about districts. Look at the districts and ask, if a district were a state, which districts would that corporation have PJ with? Now, last point on corporations here. The whole point of this whole thing about, where somebody is domiciled, where a corporation is subject to PJ, that's not to determine venue. That's to determine one word only: residency. Residency. And the only part of the venue statute where residency matters is in B1, which looks to where the defendants reside. The other parts of the venue statute, B2 and B3, residence doesn't matter. Okay? Well, in 3 a little bit, but I'll explain that in a second. But residency, for purposes of venue, matters under B1, but not B2 or B3. Now, B2 doesn't look to where the defendants reside, or they have PJ. It looks to where stuff happened, or omissions occurred, right? Or where there were omissions, where the substantial property is located. So here you're going to want to look for facts like, where did the accident happen, right? Where was the failure to perform? Where was the property that was the subject matter of the claim? Where is it located, right? That's going to be clues that we might have 1391 B2 venue. Now, you can have venue in multiple places under 1391. So say, for example, there is an accident in Alaska, and you have Alaska versus Miami and Tallahassee. Well, I can think of 3 districts in which you're going to have venue. First, you're going to have the Southern District of Florida. Second, you're going to have the Northern District of Florida. And that's because of B1, right? Because all the defendants are residents in the same state. And because the accident happened in Alaska, you're going to have venue in the District of Alaska. I guess that's an A, a K. I always forget whether it's Arkansas or Alaska, but you get the idea. And that's because of B2, where the accident happened. So venue doesn't have to be in one place. It's not like domicile, where there's only one domicile you have. Even though you use domicile to determine residence, for purposes of venue, you could actually end up with a whole bunch of places where venue would be proper under 1391. Okay? Where stuff happened, B1, B2. Looking to where people reside and running from that, you might have one or more places under B1. And all of these venues would be appropriate. Well, that's B1 and B2. What about B3? All right? B3 is a fallback. It only kicks in if and only if you have no venue at all under B1 or B2. So B3 is like a safety valve. And indeed it says, if there's no district in which an action may otherwise be brought as provided in this section, that's the threshold. B1 and B2, you got nothing. If so, then you can use B3. Then venue's okay in any judicial district in which any defendant is subject to the court's personal jurisdiction with respect to such action. All right? Well, imagine this. Here's a scenario that I like to use. Citizen of California sues somebody who's Miami and someone else who's Pittsburgh. And cause of action is a battery that happened in Mexico. All right? You know what happens? Y'all go down to Tijuana, Mexico, or Cabo Wabo, or whatever, and you have a little bit too much tequila and have some good time. Before you know it, the Pittsburgh person and the Miami person are pounding on somebody from LA. How awful. Well, now you have a lawsuit, right? California versus Miami and Pittsburgh. Well, you can't use B1 because these two folks don't reside in the same state, do they? Can't use B2 because what happens in Cabo Wabo stays in Cabo Wabo? Well, yeah, you don't have any errors or omissions that happen in any judicial district. So you can't use B1, can't use B2, use B3. Well, any district where any defendant is subject to the court's personal jurisdiction regarding the action. Well, doesn't this stink for the plaintiff? All right, Miami is Southern District of Florida. Pittsburgh is Western District of PA. Yay! And of course, the person who lives in Pittsburgh is going to be subject to PJ in Western District of PA. He lives there, right? And Miami, she's going to be subject to PJ in the Southern District of Florida. She lives there. She's domiciled there, right? All right. So we have venue over both of them in either of these districts. But guess what? Are we going to have PJ over both of them in either of these places? If we sue in Miami, Southern District of Florida, we'll be venue over both because the operation will be 3. But is it going to be personal jurisdiction over this guy in the Southern District of Florida? No. And vice versa. If the lawsuit's filed in the Western District of PA, there's going to be venue over both. Remember, it says there's venue in any district where any defendant is subject to PJ. So venue is going to be proper over both. But if we file the lawsuit in the Western District of PA, it would be PJ over this guy, but not over her up top. Because nothing in the facts show that she has any contacts with Pennsylvania. So we have kind of a gap there in the venue and the venue statute. Not a gap in venue, but rather we have a PJ problem. All right, there's other things to get into with venue, such as transfer under 1404 when venue's proper, right, but it's inconvenient. When you have a venue transfer under 1406 where venue is improper, all right, so go back in your materials, look at that. I have videos about that stuff on my website, but otherwise I'm going to move on, okay? I'm also not going to talk about forum non-convenience. If we had about, 3 more hours to talk, then I do it, but today we don't. So thank you.